Happy Monday, everyone. It's Chris coming to you today with today's Monday Moment. And in today's Monday Moment, the question that was presented is, what is a deposition? So you've been injured in an accident and it was not your fault. And then in the pre-suit, they do not give you a good offer. So you file for litigation. Ultimately, then, too, you're going to end up being deposed or being put into a deposition. So a deposition is going to be sworn testimony that's out of court that can, where the defense can ultimately ask you questions. And there's reasons why the defense is going to do this and finds it useful for themselves. And so some of those reasons are as follows. So the first big reason is they want to gain information. So what they're going to try to do is ask a variety of different questions and get you talking, because they want to try to gain any information that they can to help either poke holes in your case or help support and bolster their case. And then next would be is they want to be able to hold you accountable. Because the deposition is sworn testimony, that means that this can ultimately be used against you later. So a lot of times there's a kind of like a trick or tool that we're taught is to have the transcript of the deposition in a red folder. So then as you are at trial and you are on the stand now, to be able to pull out that deposition out of that red folder and say, I've got you here, you're accountable here. Remember, you said this thing back here, you've changed your story. Additionally, too, is the other thing they want to do is be able to record the testimony. So your testimony is ultimately recorded, and then it'll be transcribed into a transcript. So if for some reason something happens where you're unable to show up to the actual hearing itself, they still now have a recorded testimony of you months prior from the trial, but that they could potentially use at trial itself as well. So a recorded statement, recorded testimony of yourself giving answers to questions. And then lastly, too, is going to be a recall of details. So if you think about these days, and especially because when COVID, how COVID has pushed trials way back, it's to recall information as it's more fresh in your mind. So, the auto accident happens. Now just, at a certain point, then there's going to be a deposition. Well, then still now you're talking way down the road, you potentially would end up having trial. So those items now would be more fresh in your mind than they would all the way down at trial had you not given testimony at the deposition itself. So it's a tool that the defense is wanting to use to try to gain information and things like that. Our number one key that we want our clients to do then is to tell the truth. And so a lot of times that'll be things, they may not remember something. So the big answer there just would be, I don't remember. You don't want to make things up or try to guess, because that can ultimately come back to hurt you. And so you want to make sure that you tell the truth. And if you have a deposition coming up in a litigation, a personal injury litigation case, and don't know what to do, feel free and reach out to us. We've got a whole process on how we walk our clients through that. Plus here at Springs Law Group, one of the things too that we have is if you go to our website, there's a whole FAQ page as well on depositions itself too. So hopefully you guys find that helpful. And if you do have questions, feel free and submit them, as we will end up showing those or I'll end up answering those on our Monday Moment down the road. Hope everybody has a good day, and we will talk to you all later. Bye now.